All rise. The Court of Appeals Division 1 is now in session.
All right, go ahead and be seated. Welcome, everybody. Thank you.
Thanks.
All right, good morning. First order of business, please do not feel obligated, but feel free to remove your mask for the argument if that's your preference. We are here for oral argument in UB 19-0093 JR v. ADS. As counsel may be familiar, we record and live stream these proceedings, so please give your name and the name of your client when you begin. According to our current protocols, you will be arguing from counsel table. You have 20 minutes per side, and you are responsible for keeping track of your time. We recognize the clock is on the podium, and that may be more difficult to see from where you are. Feel free to move about a little bit as you need to keep track of your time, and we will try to give you. Oh, do you have a? Okay. Yes, please feel free to keep your own time if that's you. Whatever. We're being very accommodating right now. We want you to be able to make your arguments. We appreciate your accommodations in arguing a little bit different circumstances. Now, keep in mind, we've read all the briefings, supplemental and otherwise. We've studied the record. We've already discussed the case in our conference. And with that in mind, you may proceed.
Good morning, Your Honors. May it please the court. My name is Sai Mantra, and I'm here to represent my client, Mr. Jaden Ruis, who is the appellant in this matter. I would like to ask permission to reserve 5 minutes for rebuttal. My client's DDD benefits were erroneously terminated when he turned about a month after he turned 6 years old. And my client is pleading that this court should vacate the underlying decisions with regards to his termination of benefits. There are three main issues that I would like to present to you during this oral argument. The first issue is the burden of proof. The second issue is the due process violation. And the third issue is the obligation of assistance. All three issues are actually intermittent with each other. They're interrelated with each other. So it's more of a circle than seeing those issues separately. And I'll talk more about it during my argument. The standard of review for this court is de novo. And this court should also overturn a decision that is arbitrary, capricious, or an abuse of discretion, or not supported by the record. The relevant facts of this case: about a month after my client, Jaden Ruis, turned 6 years old, in November of 2017, he received a notice of intended action to terminate his Division of Developmental Abilities Services. Moving forward, I'll just call it DDD. His benefits were terminated on August 31st, 2019, just about a year ago. It is not disputed that Jaden has autism. It's stipulated on the record. But ADS, the state, terminated my client's benefits for lack of evidence showing that he had 3 out of the 7 substantial functional limitations. The procedural posture for this case, Your Honor, is the notice of intended action was received in November of 2017. An administrative review was requested in December of 2017. An administrative decision was made terminating his benefits in March of 2018. And my client properly appealed. A pre-hearing was conducted in May of 2018, and ALJ decided his case. The administrative law judge decided his case on September 20th, 2018. The ALJ's decision was that the burden of proof lies on ADS However, my client did not have evidence showing 3 SFLs out of 7. SFL as in substantial functional limitation.
So
But-
counsel, let me ask you this. Let's say we decide that the AC was correctly decided, the DES bears the burden. If the ALJ found, under the correct burden of proof, that your client didn't have the requisite SFLs, then aren't we done?
Your Honor, the 3 SFLs is a matter of fact, but I am here today arguing about the law and the legal analysis and the legal conclusions. And I'm heavily dependent on Washburn, I'll call it AW, and Kroner, I'll call it AC. AW and AC are very similar cases to this one, as similar as the facts are very close. The issues that were there, both cases were simply based on legal analysis that was conducted by the board and ALJ, and the issues that were presented in both cases are very similar to the issues on this case. There might be a minor difference in the in the facts of the 3 cases, but I'm here today to plead this court to look at this case de novo and from a legal standpoint. In AW, the court went and discussed deeply about the due process violation. Kroner, on the other hand, had elaborated on the burden of proof requirement using the Hartig tests. And my oral argument and my briefs are based upon that, and that's what I want to argue today.
Well, if we follow AC, though, we really don't need to reach the due process issue, do we?
If we follow AC, I'm arguing AC, or I'm using AC for the burden of proof issue and the obligation of assistance. I'm heavily relying on the Washburn case for the due process because it has been elaborated quite extensively in Washburn. The administrative law judge has decided that the burden of proof is on the state, but there is the lack of the 3 SFLs. However, when it came to the appeals board, the appeals board decision came out in February of 2019, and during that decision, the appeals board decided that the burden of proof has to be shifted onto my client, and also he has the lack of the 3 SFLs out of the 7. But when the appeals board talked about the shifting of burden, the reasoning it gave was it held that the DDD services, when they terminate the DDD services, there should be a significant change in the circumstances. And my client simply turning 6 would be a change in the circumstances, and therefore the burden of proof now shifts onto my client. In Kroner, that's exactly the same issue was evaluated, reviewed by this court, and it did find that that burden doesn't shift just because someone turns 6 years old. And this court, in coming up with the argument, it used Washburn, where it said there is no statute that requires the automatic termination when a beneficiary turns 18, and the court cited ARS 36566B and C in coming up with that holding. I'm actually now moving into my arguments from the procedural posture. The first and foremost argument between the 3 cases, Washburn, Kroner, and my client's case, as I mentioned earlier, the facts are very similar, but the issues are pretty much the same. All 3 issues have been discussed in all 3 cases. The issues that I'm trying to bring to the court today, the burden of proof, due process, and the obligation of assistance, have been discussed both in Washburn and Kroner. Washburn is now a determinative case. Kroner, on the other hand, a petition for review has been filed, but even if it's not taken as a determinative case, the legal analysis for the questions that the issues that the court is looking at and the questions that are supposed to be answered, the legal analysis on Kroner would still apply. If the court were to apply the same analysis, it would come to the same conclusion on this case as well. Again, citing to the ARS 36566, looking at the ARS 55119, which talks about the disability, developmental disabilities, and through the state's own regulations. Now, I also would like to argue that Kroner tried to decide there is from between the ARS 36566, which does not automatically which automatically terminates the beneficiary when he turns 18. It does not do that when a child turns 6 years old. On the other hand, 3655119 talks about at-risk potential before a child turns 6. When both of them are put together, the state argues that when a child turns 6, before the child turns 6, or when he's from the infant stage to 6 years old, it's an at-risk potential. So automatically, the statute would mean that after 6 years old, his benefits are to be terminated, or if not, they have to be looked at a stringent standard. On the other hand, we also have the 36566, which actually clearly says that once you turn 18 years old, unless you pass the stricter stringent standard, your benefits would be terminated. The gray area lies between when someone turns 6 years old and before they turn 18 years old. This court grappled with that issue and tried to resolve that issue in Kroner by looking at the burden of proof issue and resolved it by saying the burden of proof still stays on the state who's trying to change the status quo. However, in its own answering brief, the state does agree that its own answering brief, the state does agree that I want to quote it, Your Honor, but before I waste my time trying to find it, the state agrees that if it's seen that you have to be held at a stricter standard once you're 18 years or older, anything less than that would mean anyone that's at risk would have to be provided the benefits. So my argument is, so be it. Just like a driving license, you apply for a driving license, it's still a privilege. But if you're entitled to get a driving license, you would get it. Same thing with the benefits. The state argues that it comes up with it is an absurd result if you were to provide benefits for everyone that's at risk under 18 years old. But from the clear tone of the statute, it doesn't say they should not. That goes to the state. About 5 years ago, the state had a different attitude towards how they deal with disability development benefits. At the time, it was an attitude of customer service. What has changed between now and then is that now the state acts more like a regulating authority and a gatekeeper in trying to provide these benefits instead of looking at it as a customer service. The state clearly says that they don't provide services, but under 6601, under their own rules, it does not take away their obligation of providing assistance.
Counsel, if we agree with you that AC is controlling here on the burden of proof, that we accept the analysis of AC, how is the error, there would have been an error in application of the burden of proof, how is the error not harmless in this case? Because I see some significant differences in the facts, the health, the functional limitations of AC versus in this particular case. But how do we weigh that, or what's your argument that this is not harmless? This is not a harmless error in this case?
Your Honor, it is a harmless error only because of two reasons. Actually, two reasons. One, the burden of proof was shifted upon my client without giving him proper notice on what type of testing, what type of evaluation was supposed to be looked at. This burden of proof issue also goes on the obligation of assistance, in the sense as there was no assistance provided to my client to be able to get the evaluations and the testing that the state is supposed to, the state was looking for. The obligation of assistance the state is obligated to assist in all aspects of the delivery system, quote, and including the pursuit of evaluations and professional assessments. There was no case manager. There was no assistance provided. There's nothing on the record that there was any assistance provided. And this burden of proof issue, because it was shifted on my client, violates both the due process as well as it also affects the obligation of assistance. And that's how we feel that it's harmless, Your Honor.
Go ahead.
I just wanted to note for you that you have about 5:45, so if you're wanting to save some time.
I want to ask a follow-up question very quickly to that, which is, if that's the case, when the ALJ ruled against your client, why wouldn't that lack of assistance from ADS and DDD have been brought up then? Why isn't it waived? Because it wasn't, even if the burden hadn't shifted, he was losing. And that certainly seems like an argument that could have been raised at that point.
Your Honor, my client is a pro se client. He is not completely knowledgeable of the procedures and process of the court. The second, that just happens to be a minor reason, but the second reason is the first time that he was the notice of intended action did not mention anything about the substantial limitations. The first time he ever heard about it was at during a hearing of the pre-conference in May. For that, the notice for that hearing went out to him on April, and the hearing happened in May, and that's the first time he ever knew about the substantial functional limitation. This one, it was coming right in front of the administrative law judge, this hearing, and that hearing didn't say anything about what substantial means. If you look at the expert witness's testimony, she defines substantial very narrowly on what she's looking for. She talks about the 2 standard deviations. However, Kroner has cleared it that you have to compare it with your peers, but it doesn't say anything about what kind of testing they were looking for. It doesn't say anything it doesn't provide any assistance. All it says is that the issue at hand is the 3 SFLs out of the 7. That doesn't provide proper notice to my client. And to answer the question about the assistance, my client didn't even know about the assistance. However, that goes to the burden of proof. The burden of proof is on the state to show that they had provided assistance. They have provided evaluations. They have to be providing evaluations at least twice a year. It's the state's burden to do all of that. Without doing any of that, they simply just let my client know that there is lack of evidence. I see that my time is up.
We'll stop the timer if you'd like to reserve. You still have 3 minutes, 12 seconds. You can save that for rebuttal or keep going.
Yes, Your Honor. I would like to save that.
Ms. Felger?
May it please the Court, my name is Joanne Falgett, and I'm here representing the Arizona Department of Economic Security and its Division of Developmental Disabilities today. I have just a couple of quick corrections to some erroneous statements that I believe I heard, and then just a couple of quick, really critical points I'd like to make. First of all, the standard of review is that this court is supposed to defer to the agency's findings of fact, and then, of course, reviews any issues of law de novo, and I think that might have been perhaps misstated accidentally in claimant's argument. Second, the PFR for the AC case has not actually been filed. I've moved to extend the deadline for that. It's due on September 21st, 2020. So I wanted to correct the record on that as well, in case that affects this court's decision in any way. Moving on to the actual argument, it is absolutely critical to this case, if the court is considering not following the AC case, to understand that JR has never demonstrated eligibility for the DDD benefits as a, quote, person with a developmental disability that he now claims he's entitled to, because there are two ways to qualify for DDD services, and the method by which he qualified provides benefits only for children under 6 who have, quote, a strongly demonstrated potential that they may have or might in the future have a developmental disability. And that's under 36559A. The plain language allows DDD benefits if a person is an Arizona resident and is an infant and as a result of tests performed, blah, blah. There is a strongly demonstrated potential that the infant has a developmental disability or will have one. Later in the statute, under the definition section 55119, it becomes clear that the term infant refers to children under 6. The at-risk category is the category under which JR qualified for benefits, but those benefits are available only to children who are 1, Arizona residents, and 2, under the age of 6. I think it's pretty undisputed that if he were to move out of Arizona, his eligibility would terminate. Similarly, when he turns 6, his eligibility terminates. Also under 36-559A, there's a second way to qualify for benefits, and that is by demonstrating that the person is a person with a developmental disability and provides medical and psychological documentation of such developmental disability utilizing tests which are appropriate and valid. That's 36-559A2 again. And ARS 36560C provides that a person shall not receive developmental disability services unless proof of the requirements set forth in Section 36559 is provided. I think the clear import of these statutes is that when a person turns 6, if they qualified only under the at-risk statute, they now have to prove eligibility under the higher burden of proof. Now, the reason that the statute doesn't automatically terminate all benefits, unlike it does when somebody turns 18, is because you can qualify as a person with a developmental disability, even if you're under 6. So it wouldn't make sense to automatically terminate everybody's benefits. But just the plain language of the statute indicates that if you qualified only under that at-risk category, then when you turn 6, you have to provide proof, or DDD is not authorized to provide services.
Counsel,
yes.
Isn't DES under its own regulations required to provide the assistance to the person to help them prove their qualification?
Certainly.
And where is that in our record here that DES provided any assistance in getting that information?
So the issue here is that because DES went forward under the mistaken idea that it had the burden of proof, A, under the AC case, that wouldn't be relevant, but B, nobody raised it as an issue. In the administrative decision, it was identified that the only issue was going to be the substantial functional limitations. In the pre-hearing statement, it was identified that the only issue was substantial functional limitations.
But in the notice, it was identified as whether he had autism. So you can't say the record is clear on this. It is at best ambiguous, isn't it?
So this is something that I believe that AC and Johnson got wrong, was that notice of intended action is not the decision from which appeal lies. That is merely the department's informal notice to the person that, hey, we're thinking about terminating your services.
Actually, if he doesn't ask for a review, it's a final notice.
It would be final if he doesn't ask for a review. If he
so
consents.
It is the notice.
But what gives rise to the formal review, and the regulations actually say, let me find that. What gives rise to the formal right of review is the actual administrative decision that results if the person challenges the notice of intended action. So when somebody goes to terminate here we go. So section 35-565 establishes the review and appeal procedure for decisions relating to the admission, evaluation, assignment to programs and services, care and treatment, and so forth. And that's 36-563A. And it requires DDD to periodically evaluate each claimant's placement, and then the department has to provide them with 30 days written notice of any proposed transfer, termination, or substantial change of service, and that's that notice of intended action, and shall inform the client in writing of the right to an administrative review pursuant to 36-563. And that's when the administrative review process starts. So once the client challenges the proposed action, it's only an intended action, it's not an action they've taken, then they look at it one more time and make an actual decision about what they're doing. Because one of the ways you can terminate services is if the person actually asks you to.
So let me ask this. When Dr. Gray did her report and said, hey, I'd like to see a Vinland report, an ABIS report, there's a lot of acronyms in there. When she said that, under the regs, why didn't DES do that? Why didn't they get that? If they're obligated to provide assistance,
Sure.
Why wouldn't they have gotten those things?
So a couple of things here. First of all, I think that the court in the AC case and in AW in its dicta erred by taking the lack of evidence for a proposition to mean that there is no such evidence and that the proposition is therefore false. In other words, the lack of evidence that that DES provided appropriate assistance, they took that to mean they must not have done it. But it was merely a lack of evidence. Just like any trial, people narrow the issues that they're going to try and they present relevant evidence. Whether they assisted or not, even under the AC case, is not relevant when DDD is bearing the burden of proof. So
it is relevant, though, if ADS bears the burden. It's highly relevant.
No, actually what AC said was if we were switching the burden of proof onto the person, then it would become relevant that ADES hadn't helped them and they could raise that as a claim. And so AC said because the ALJ in that case had applied the burden onto DES, that they wouldn't have known to raise it at that stage. But you know what? The flip is true as well. DES wouldn't have known to raise it at that stage either. And I submit that the AC case got that wrong by simply deciding that because there was no evidence on an issue that hadn't been identified as an issue for trial, that the evidence had to go against DES instead of remanding for fact-finding.
Well,
so if
when
this
was
court,
he supposed to raise it? If it wasn't until the final decision that he has to appeal that they shifted the burden. So there was no hint that that was a problem. And so we've got, we start with, well, they didn't bother to tell him the right reason they were terminating. Then he appeals, and finally, about a month before his hearing, he gets that information. And then at the last minute, they say, oh, by the way, we're going to put the burden on you for all of this. When was he supposed to say, wait, I'm not getting the help I need?
so he can say it at any time, even while he's going through the process. If he thinks he isn't getting the help he needs, he could say so. And there's no evidence in the record that he did. So just as the court in AC presumed that DES didn't do its job, this court could just as easily presume that JR didn't do his job by objecting that he wasn't getting the help he needed, or by raising that as an issue, which even if it's not directly relevant, if DDD has the burden of proof, and I'm not really sure I agree with that in the AC case either.
Well, let me ask you this. If the burden has shifted, and there's no evidence that DES provided in the record, do we have to remand? Isn't it done? There's no evidence in the record to support DES's position.
But DES would have been just as taken by surprise by the board's position as.
So DES would like the opportunity to provide that information,
Well,
as opposed to us just simply saying
it's
the
not
burden's
just-
on. Let me finish. But the burden's on DES right now, and with the record we have, there's nothing here to show that he was given the assistance required. Doesn't that mean we just simply reverse? And we don't need to deal with remanding for further proceedings?
Well, if the issue wasn't even identified as an issue to be considered, then I don't think this court gets to just decide what the facts are without a factual record on that issue.
Well, let me ask you this, though. The record's clear that Dr. Gray would have wanted the Vineland, the ABS, all these other reports. She would have wanted a current, readily available IEP. And the record's clear, DES didn't get them. So if the burden was on DES and DES didn't get them, why do we need to remand? It's just simply
the record
error.
is not that clear. So, for example, she had stated that she would have wanted updated records. For all we know, the case manager repeatedly asked JR to provide them or to go get these tests, and even helped him try to call and set up appointments, and he just either
But
got them
you're
and
going
didn't-
outside the record now. I'm going to stay inside the record.
Okay, and I'm saying...
Your client's expert said, I can't say whether he has and meets the requirements for these SFLs. I always get them, I mix up the acronym. And because I don't have these tests.
Actually, that's not what she said. She said, we would like to see more recent tests because if things have changed in the interim, then that would be nice to know. But the evidence, and if you read through her testimony and read through the
Her
ALJ's...
testimony doesn't say he doesn't have SFLs. She doesn't say he doesn't.
But
She says the evidence doesn't establish them.
The ALJ, though, went further and looked at the actual documents that she had testified about, took her testimony into consideration, looked at the documents, and wrote a very compelling decision, which states not only was there no evidence that JR presented that he did meet the criteria, but the evidence that DES presented shows that he didn't. For example, the child was potty trained and could use utensils and drink out of a cup and could run and walk and understood the value of money and understood the danger of heat and of traffic, and so met all of these criteria, and that was at the age of 3. And she did testify, Dr. Gray did testify, that it was unlikely that he would regress in those areas. The only area...
And I may have follow-up on it, but that relates to the SFLs, in particular, the ones regarding... I flipped my page. One of the 7 that regards to independent living, with regard to the things that generally we'd expect as people get older: self-direction, independent living, economic self-sufficiency. It was very clear in AC that Dr. Gray discounted those. Don't we have really the same record here? She said even, I consider his ability to do chores if he were older, but he's not.
But what she said also, in addition to saying that, is, in addition to that, and I can't remember which record it was, one of the records had said that he does do some chores at home. And she said, and that would be in line with age-appropriate development for that category of stuff. She was not nearly as...
But she finished that sentence by saying that I consider if he were older.
And again, because
what she said
because what she was saying is those records were from when he was 3, and so now that he's older and he's 6, and she's presuming that he's not going to regress in the ability to do chores, that he therefore meets that peer appropriate standard of being able to do minor chores at the age of 6. And she explained that nobody expects a 6-year-old to go out and get a job and fully support themselves and pay all their bills, but that his information that was in the records, in the IEPs, in the reports from the occupational therapists and the speech therapists and everybody else, indicated that he had apparently developed pretty much age appropriately, maybe slightly behind in a couple of areas, with the exception of the speech and language. And that was the only area identified in any of the documents as an area of problem for him. And she testified that was a problem. The ALJ found that the evidence was conflicting, that DDD had not borne its burden of proof, and therefore he had an SFL in that one area. There was evidence supporting the direct finding, with DDD having the burden of proof, that based on the evidence, he was not, didn't have SFLs in any of these areas. Back to the provision of help, there is evidence in the record to support the fact that DDD did try to obtain more documents. For example, JR was asked, what about the recent IEP that Dr. Gray mentioned should have been here? And he said, I forgot to submit that. So apparently somebody told him to submit it and he just forgot. So there is some evidence in the record that he has been asked to provide records. We also have the fact that there are lots of records that have been collected and preserved and analyzed in the record. So clearly they were asking him to submit stuff. And she testified that things like occupational therapy notes and speech language notes, therapy notes, can be the kind of thing you rely on, but that she was surprised that there were no actual data or tests in those. So again, we don't know, based on this record, whether DES didn't ask for it or whether DES asked for it and JR simply didn't provide what had been requested. And I think it's only fair, if the court wants to look at that assistance issue, that it remand for fact-finding. And along those lines, I would point out the board can take new testimony or can remand to the ALJ to do further fact-finding. And additionally, people do have an opportunity to file a motion for reconsideration with the board. So if this was an issue at the board level for the first time and the board came out with this decision, JR could have filed a motion for reconsideration and asked for an evidentiary hearing on the assistance issue. Clearly, could have pursued that issue, and I submit has waived it by not doing so. This court can remand to the board, which can then do that fact-finding itself or remand it further to the ALJ for a full-blown hearing on whether there was appropriate assistance, if this court thinks that the burden of proof should switch to JR, which I think it should, in which case I think we should remand. For my client's sake in this case, if you follow the AC case, I agree that, it doesn't need to go back. The ALJ applied the correct burden of proof. The board upheld all of its findings and specifically said that it adopted all of the findings on the 6 SFLs except for the speech and language. And those findings specifically said DDD bears the burden of proof and has proven that there is no SFL.
What is DES's burden? I want to be clear on what you consider DES's burden if we send it back under AC.
So then DES would have the burden because the burden, well, I guess there wouldn't be. If you approve AC, there doesn't need to be any further fact-finding because under AC, if DES had the burden, the issue about the assistance is irrelevant. And DES successfully
But doesn't
bore the
DES
burden.
bear the burden of proving, not based on the evidence, but they bear the burden of proving that JR doesn't have 3 SFLs. Isn't that the burden?
Yes, and that's exactly what the
So
ALJ
where on
found.
this record do we find that he doesn't?
So if you read the ALJ's decision, it's very clear on each of the SFLs, and here I'll get you a citation.
Didn't the ALJ also make a comment about the evidence that JR produced? And it's not JR's burden to produce it, it would be DES's burden.
Of course not, but any time you have a trial, whichever party has the burden of proof, the other party is of course allowed to present contravening evidence.
That's only triggered if the other party meets its burden to begin with.
And the ALJ...
So where did DES meet its burden? That's what I'm trying to figure out.
The ALJ found that DDD had the burden of proof and that for each of the 7 or each of 6 of the SFLs, it had definitely proven that there was no SFL. For the one SFL where there was conflicting evidence, DES had presented some evidence that the child was not substantially delayed in the speech and language area, but the child had presented evidence that there was a substantial delay. That was conflicting evidence, and so the ALJ said, under the burden of proof, DES did not meet its burden, and so I find that he has this one SFL. The board approved wholesale all of the ALJ's findings on the 6 SFLs that the ALJ found that DES had proven he did not have, and said, but they applied the wrong burden of proof. And so for this one that the ALJ found, if you put the burden of proof where it belongs on the child, then he doesn't have that one because he didn't prove it. The evidence was conflicting.
So if we follow AC, and this goes to Judge Brown's question, what's different in this case that says we shouldn't find harmless error? Why is this case different?
I understand, and I have an answer for you. I have an answer for you, Judge. In the AC case, it was the same situation. The ALJ had applied the incorrect burden of proof, I guess this court says it's the correct burden of proof, placing the burden on DDD. And that tribunal had found 2 SFLs. On review, the board applied the different burden of proof, reversed on those 2, but found a different SFL. And so it was possible that if applying the correct burden of proof, the board might actually have approved the 2 SFLs that the ALJ had found and found the third one. And so that made sense. They would have, in that case, potentially had 3 SFLs. But here there was only ever 1 found. Under no set of circumstances, under any burden of proof, has anybody ever demonstrated that this child has 3 SFLs. And so this court can simply affirm if it agrees that the correct burden of proof was on DDD. I would like for this court to disagree with the Kroner case and write it correctly because the plain language of the statute says that when this child turns 6, he now has the burden to prove this. And the problem that DDD has is if it has to spend a lot of money providing services for children who aren't actually eligible, it quickly runs out of funding to provide services for children who are. And it has limited funding, and when the funding runs out, it's done. It doesn't get more, and the legislature has only approved a certain amount. Also, I would request that the court disagree with Kroner and Johnson on the attorney's fees statute issue. If services that DDD pays a third-party provider to provide and or pays its own people to provide, pays actual money to provide, is not an equivalent to a monetary benefit, I don't know what is. Thank you, Your Honors.
Your Honor, my client was qualified by the state, and he did prove that he had a strongly demonstrated potential for a developmental disability. He doesn't need to prove that again after he turns 6. Once he's in the system, he's already in the system. That's exactly goes with the statute 36-551-19. The state argues that the statute actually says once they turn 16, the burden of proof turns to my client, and it actually doesn't. There's no such thing on the statute. The one issue that the court just brought about the lack of evidence, the same arguments is the same arguments that the state is advancing were the arguments that my client did. When they put the burden on my client, they say there is lack of evidence. You didn't give me enough information for me to look at it, and or you didn't give us enough information for our expert witness to evaluate. But the expert witness was selective in what she was looking for. She was actually looking for statutory language in a medical report. There was one instance where it says the medical provider mentions developmental disability, which also is defined by the substantial the SFLs, but she says there is no the language of the SFL. That's what happened with this whole case, is that the witness, there is no assistance, there is no mention of a case manager.
Let me ask you a question. I want to just get really direct. She argues that there were 3 potential SFLs when we sent it back based on the case. Here there's only 1. How do you respond to that?
Could you rephrase the question?
In other words, that if you take the 2 that the ALJ found and the 1 that the board found, that's 3, and that would qualify AC. But here for JR, the ALJ only found 1 and the board found none. So how do you respond to that argument that you can't do the math to get there on the record we have?
The argument on that is, again, the burden of proof is on the state. If it had provided proper assistance, the evaluated twice every year, and provided all the testing requirements, nothing in the record shows what was required as part of the testing.
Counsel, doesn't there need to be a reasonable likelihood that there are 3 SFLs that could be established? Was there a reasonable likelihood that there'd be 2 more? Because there was only 1.
Your Honor, the likelihood that the ALJ found and the state argues comes from the one expert witness, like I said, who's looking for selective information. If they disqualify or discount all the pieces of information that's actually available there, the progress reports were. My time is up, Your Honor. Would you mind if I continue?
You can complete your answer.
Yeah. The selective evaluation of the reports is the problem with what was presented as evidence, while the proof of burden was on the state, and that selective evaluation pretty much discounted everything. The progress reports were discounted because of a lack of testing, where my client was never put on notice on what that testing means. The doctor's reports were also discounted, one for testing, because the only mention of testing happens at the hearing about the Garin but the testing that the medical professor, Dr. Pajero's medical record is completely discounted. At the same time, it also talks about the medical professional's record doesn't have statutory language in it. So if someone
Thank you, counsel. I think that's sufficient. We appreciate your arguments. We will take the matter under advisement and issue our decision in due course. Court stands adjourned.